Donald Trump's Department of Justice just fell into a perjury trap of its own making, and it relates to the Abrego Garcia case. They turned an issue which they could have resolved simply by facilitating his return back to the United States and deporting the guy to Costa Rica, which would have been cruel but lawful. And now they've made this a major issue where they've trapped themselves, and it's clear to a federal judge in the Middle District of Tennessee, Judge Crenshaw, that they engaged in perjury. So the federal judge just unsealed a order that he made prior to having to cancel the Abrego Garcia criminal trial, which was scheduled to take place at the end of January. Instead of the trial, the federal judge said, we're holding an evidentiary hearing. And in this evidentiary hearing, Trump's DOJ, you better put on witnesses, be that Kristi Noem, Pam Bondi, Todd Blanche, a guy by the name of Akash Singh, or even the United States Attorney for the Middle District of Tennessee, Robert McGuire. Go on the stand because you've made a lot of representations to this court that clearly seem to be false. There is a presumption that y'all have engaged in what's called a vindictive prosecution against Abrego, and if you don't rebut it, not only will the case get dismissed, but it seems pretty clear that y'all engaged in a massive conspiracy here, by the way, which I think in a future DOJ could be grounds for an investigation. Now, the thing that this Trump DOJ has been saying over and over again in the Middle District of Tennessee is, oh, Donald Trump and Todd Blanche, his former criminal defense attorney turned number 2 at the DOJ, and Pam Bondi and Kristi Noem, they had nothing to do with criminally prosecuting Abrego Garcia for something that went down in 2022 for which he was not arrested back then when he was returned from the El Salvador detention center, the terrorist detention center, which I call a concentration camp, back to the Middle District of Tennessee. And they said, oh, it wasn't anything to do with the fact that Trump and Todd Blanche wanted this guy criminally prosecuted. For real, the United States Attorney, the acting United States Attorney, the top federal prosecutor in the Middle District of Tennessee said, I made an independent decision on my own, had nothing to do. I just figured, there was a traffic stop with Abrego back in 2022 that he was never charged with. And I just thought, you know what? I'm going to charge this guy with smuggling labor, and we're going to call it trafficking. And then we're going to try to blow this up to retaliate against the guy. That's just McGuire, the United States Attorney, acting United States Attorney, goes, that's just my call. But then what the judge says is, nope, and this order was just unsealed. The federal judge is like, in the emails that I made you turn over, you tried to distract me by dumping a bunch of meaningless records that were actually not the records I requested. But in the records that you turned over in the thousands of files, I clearly see where the DOJ in Washington, D.C., where Trump and Todd Blanche and Bondi ordered Robert McGuire to go after Abrego Garcia. I mean, there's emails from Blanche that literally say, this is a top priority for the DOJ that you go after the guy when his return was facilitated back from El Salvador. Let's take a look at how Roger Parloff, he's doing a great job reporting on this. Here's how he describes it. He goes, in the USA v. Abrego Garcia, here's a quick summary of what Judge Crenshaw's newly unsealed order from December 3rd shows and means. So we were wondering, what evidence did the judge have to cancel the trial and hold this evidentiary hearing and say, Trump officials, you better show up right now? Well, now we know. 3,000 documents were reviewed by the judge. A lot of the documents were irrelevant, but the judge focused on a group of documents that were highly relevant, and specifically where the U.S. Attorney Robert McGuire previously swore under oath that he alone decided to indict Abrego Garcia. Emails show, per federal judge Crenshaw, that Todd Blanche, Donald Trump's former criminal defense attorney turned the number 2 at the DOJ, that's his position, Deputy AG, he told McGuire indicting Abrego was a, quote, top priority, and we want it sooner rather than later. Specifically, it was an order that was made, and McGuire claimed that there were no communications. There's emails, there's documents. Look what the judge says here. The central question after Abrego established his case of vindictiveness is what information in the government's control sheds light on its new decision to prosecute Abrego after removing him from the United States without criminal charges. These documents show that McGuire did not act alone, and to the extent McGuire had input on the decision to prosecute, he shared it with Singh and others. Singh, Akash Singh, he is the right hand of Todd Blanche. He is one of Todd Blanche's deputies, and Blanche is the deputy attorney general. Specifically, the government documents may contradict, in other words, you lied, may contradict its prior representations that the decision to prosecute was made locally and that there were no outside influences. For example, Singh contacted McGuire on April 27, 2025 to discuss Abrego's case. On April 30th, 2025, Singh asked McGuire what the potential charges against Abrego would be, whether the charging documents would reference Abrego's alleged MS-13 affiliation, and asked for a phone call before any charges were filed. In a separate email on April 30th, 2025, Singh made clear that Abrego's criminal prosecution was a top priority for the Deputy Attorney General's office, Blanche. He then told McGuire to sketch out a draft complaint for the 1324 charges, making it unlawful to bring in and harbor certain allies. On May 15th, McGuire emailed his staff that, quote, Deputy Attorney General Blanche and his number one deputy, Akash Singh, would like Garcia charged sooner rather than later. Then on May 16, 2025, Counsel of Record Jacob Warren emailed Singh and reported, if the Deputy Attorney General Todd Blanche does want to move forward with the indictment on Wednesday, we think it would be prudent to loop in the press office ASAP. Finally, on May 18, 2025, Singh emailed McGuire, just to remind you, Akash Singh, he's one of the top DOJ people at Main Justice in DC. He's the right hand for Todd Blanche, right? He's emailing McGuire, who's the top prosecutor in the Middle District of Tennessee, where Abrego was charged. Finally, on May 18, 2025, Singh emailed McGuire and others and instructed them to closely hold the draft indictment until the group got clearance to file. The implication is that clearance would come from the office of Deputy Attorney General Todd Blanche, not just McGuire. These documents must be disclosed given Abrego's reliance on Blanche's public statements that this did not happen, right? So in other words, the DOJ, McGuire have all been lying. They've been exposed in the emails, despite the fact that they tried to hide this. You know who I want to bring in? Could I bring in Katie Fang from the MeidasTouch Network? You know Katie. Subscribe to her YouTube channel, by the way. Let me bring in Katie Fang because she describes this great as well. And I want to give you another practicing lawyer. She's a practicing lawyer. Her perspective on this. Katie, take it away.
What I wanted to cover with you is something that you've seen in the news since yesterday, but I wanted to break down that court order with you. It is the recently unsealed order from a federal judge in Tennessee in Kilmar Abrego Garcia's criminal case. As a reminder, Kilmar has two parallel cases that are currently going on. He's being prosecuted in a bullshit prosecution by the Pamela Joe DOJ for alleged human smuggling and trafficking. And that case was brought in Tennessee. But he also filed his own federal case, a habeas corpus case, concerning whether or not he can be deported again out of the United States. Kilmar Abrego Garcia, one of the many individuals that were illegally and unconstitutionally cheated of their due process, removed from United States soil, taken to CCOT, that terror confinement facility in El Salvador. That was in violation of an order that was entered years ago in Kilmar's case that said he was not supposed to be deported to El Salvador. He actually was going through the legal processes to stay in the United States. And so it's important when we highlight these orders that are coming from federal judges because number one, they're following the law. They're defending the rule of law. And number two, in this particular order, we see that Kilmar's motion to dismiss his criminal case because of vindictive prosecution by the Trump government. Well, we knew it was well taken, but now we're seeing that there's actually evidence that corroborates and supports his position. So let's go through this order together so that we understand all of the issues. Alrighty, so we have this order that was entered by a federal judge, Judge Crenshaw, in the Middle District of Tennessee, Nashville Division. It's entitled Memorandum, Opinion, and Order, and this was, again, previously sealed, and so the public wasn't able to access this information until it was unsealed late yesterday. So the judge in this case, Crenshaw, says that there's two pending motions. One, Kilmar's motion to dismiss for vindictiveness and selective prosecution. And two, the federal government's, the DOJ's motion to quash subpoenas for DOJ officials Todd Blanche, the Deputy Attorney General of the United States, Akash Singh, and James McHenry. They are also DOJ employees. Kilmar Abrego Garcia's lawyers have basically subpoenaed those three individuals to begin with to be able to sit for depositions and to be able to provide documents and information as a part of what we call the discovery process, the production and the provision of information either through sworn testimony and depositions or through production of documents and answers to written questions. And so in this instance, in order to prove up his claim of vindictive and selective prosecution, Kilmar needs the evidence. It's really hard as a footnote when you are a criminal defendant who's attempting to prove vindictive and selective prosecution because the burden is on you to prove it, and yet how do you prove it if you don't get the access to maybe the internal documents and communications that would prove up or evidence what you're suggesting or what you're claiming? And so it's a little bit of a catch-22. So you can imagine if a federal judge has found that Kilmar has pretty much met that burden to be able to even get the discovery in his case, that things must be pretty bad for the Trump DOJ. So what the government is doing here is they've also filed a motion to say, we want to quash those subpoenas to Blanche, Singh, and McHenry, that they would have to testify at an evidentiary hearing on Kilmar's motion to dismiss. Let me also note for you, evidentiary hearings are incredibly powerful. They are what they sound like. It is a hearing that is run by the court. There's no jury present. But the people who testify, they testify under oath, under penalties of perjury. They are subject to cross-examination by opposing counsel. And during the course of an evidentiary hearing, you actually have things entered into evidence versus just arguments that are made by lawyers. And so evidentiary hearings are incredibly powerful. And the fact that Kilmar Abrego Garcia is allowed to even have one, again, is a big win for him. In this instance, Judge Crenshaw indicates in the order that the court reviewed in camera. That means in chambers. That means that the government produced over 3,000 documents for purposes of review by the judge and the judge only. That was for the judge to be able to look through the documents before they are produced to the other side. Why? Because the government in this case said that there were various privileges that would protect the production of these documents to lawyers for Kilmar. And so the judge looked at these over 3,000 documents in camera, in chambers. That's Latin for in chambers, right? And after reviewing these 3,000 documents, the court found that it's going to grant, in part, Kilmar Abrego Garcia's motion to compel discovery and require the DOJ to disclose to his lawyers a subset, meaning some of those over 3,000 documents that are relevant to the narrow issue of whether the DOJ's new decision to prosecute Kilmar Abrego Garcia after they initially decided never to prosecute him, but instead to do what? To ship him off to CCOT, right? The judge says, you know, some of these documents are relevant to that particular narrow issue. And it's because Kilmar has argued that the decision to prosecute him criminally in Tennessee was, quote, tainted by improper motivation. What was that improper motivation? Because Trump and the DOJ was embarrassed that Kilmer had success in his habeas corpus immigration case in Maryland, and because they had mud and egg on their face and they looked like shit, frankly, in front of the American public, that's the reason why they decided to vindictively criminally prosecute Kilmer Abrego Garcia. Now, the judge also denied in part some of Abrego Garcia's motion to compel discovery and said, look, I want further briefing. I want further legal documents filed setting forth your arguments for and against why Blanche, Singh, and McHenry should have to testify at these evidentiary hearing, and it's after you consider the documents that are produced. And so in other words, what the judge is saying is, hey, Kilmer's lawyers, I'm going to give you a subset of these over 3,000 documents. Once you've received them immediately, because that's what the order says, they have to be turned over immediately, we're then going to allow for further legal briefing done, and then I will decide as the court whether these people must testify at the evidentiary hearing. So there's a process. It's a multi-step process, but there's a process. So the order in this instance is a 9-page order. You see it on your screen right now. And the judge very smartly calls out the DOJ and says, the government produced over 1,000 documents, many of which are hundreds of pages of duplicative copies of Kilmer's immigration file, as well as internal communications among investigators, attorneys, and others that have no relevance to Kilmer's motion to dismiss. In other words, it was a huge document dump that they did to the judge of all people. But the judge says, still, having reviewed all of the documents provided by the government, the court finds that some of these documents are relevant to Kilmer's motion to dismiss. They must be produced to him under a protective order, which means we, as the American public, don't get to see those documents, and only the lawyers for Kilmer get to see them. The court meticulously goes through the relevant dates in the timeline of Kilmer Abrego Garcia's prosecution and notes that when he was initially pulled over for speeding in November of 2022, they didn't give him a ticket, they being Tennessee Highway Patrol, didn't give him a ticket, didn't arrest him, let him go his way. Now, Tennessee Highway Patrol, if you will recall, did make a referral to Homeland Security based upon a suspicion of human trafficking back in 2022. But then let's fast forward 3 years to 2025, because that's when the Bondi DOJ said, we're going to deport Abrego Garcia to El Salvador without ever bringing criminal charges against him, right? So they deport him to CCOT. He then successfully challenges his deportation to El Salvador. And then suddenly the Department of Justice finds Jesus and decides that they want to now prosecute him for alleged human trafficking, right? Because he was never charged with that or any other crime until he successfully won his federal district court claim. It was upheld by an appellate court, and the United States Supreme Court said that the Trump administration had to facilitate his return from CCOT. But I know I don't have to remind you that Trump, remember Bukele, the president of El Salvador, and you had J.D. Vance, Marco Rubio, and all those other dumbasses swearing in the Oval Office they'll never bring him back. Kristi Noem, Pam Bondi, all swearing up and down, on the Bible, never going to come back. We're never either going to be able to bring him back. We cannot do it. We won't do it. He'll never be back. And then suddenly, when they're embarrassed, they're able to find him and bring him back. That's why he's brought this motion to dismiss. Now, the cornerstone of his motion to dismiss, according to the court, is that the decision to prosecute him was in retaliation for his success in the Maryland District Court, which is why when the judge walks through the timeline and the dates, you see it's pretty obvious and blatant on its face that the DOJ was just motivated by wanting to punish him. I mean, if there really was anybody who has been the subject of absurd and grotesque persecution, not just prosecution, it's Kilmer Abrego Garcia. Kilmer relies upon statements made by Todd Blanche in the media, claiming that the primary kind of thing that they're trying to do is go after him. I mean, he was dumb enough to say that. Nevertheless, and despite Blanche's remarks to the media publicly, the DOJ says it didn't decide to prosecute him in retaliation. It was actually the acting U.S. attorney in Tennessee that made this decision. But the judge notes the following in the order. The judge notes that there's actually things like emails and communications internally that show that Akash Singh decided to tell the U.S. attorney in Tennessee, listen, we want to make sure that you know that his criminal prosecution is a, quote, top priority for Todd Blanche, that Blanche would like Garcia charged sooner rather than later. If Blanche wants to move forward with the indictment, it's prudent to loop in the press office ASAP. Closely hold that draft indictment until you get clearance to file. I mean, these are the types of commands, orders, and directives that are being provided to the U.S. attorney. From whom? From Todd Blanche by way of Akash Singh and others. Now, the court says in the order, I recognize that there are certain privileges that exist that the government has asserted to protect the production of these documents to Kelmer Abrego Garcia's lawyers. But the court notes, quote, Abrego's due process right to a non-vindictive prosecution outweighs the blanket evidentiary privileges that are asserted by the government, end quote. Then it goes on to say, if the work product, attorney-client, and deliberative process privileges asserted by the government precluded all discovery in the context of a vindictiveness motion, defendants would never be able to answer the question, what motivated the government's prosecution, end quote. Makes sense. It's what we just talked about a few minutes ago. If I, as a criminal defendant, can't actually access the evidence to show that there was a vindictive intent behind bringing this prosecution in the first instance, then I'll never be able to succeed on a motion to dismiss. So the court concludes, beginning on page 8, that the government shall immediately produce these documents to Abrego pursuant to a protective order, and supplemental briefing on whether or not those those subpoenas should be quashed as the federal government is asking to happen. Here's the following dates: December 12th, December 19th, and December 23rd. All of which have come and gone. And so we're going to see whether or not actually those, that testimony is going to end up to move forward. And at this point, you got to hand credit to Judge Waverly Crenshaw, United States District Court judge in Tennessee. That judge also allowed Kelmer Abrego Garcia to be released on pretrial release, saying that he was not posing a risk of threat to the community and to the safety of the community while his criminal case is pending. And we also acknowledge that Judge Paulazinas up in Maryland said that he could not be deported again while his case is pending. These are all important rulings from federal judges that are holding the line in the defense of democracy. And as I always say here at this channel, we have to give them credit where credit is due. Be mad, be outraged, demand accountability. You know that we're going to up the ante in 2026. There's so much at stake, but we're in this fight together.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.